Imagine building a food brand, fighting your way into a saturated market and securing space on major American grocery shelves. You scale the business, you get the product in front of thousands of consumers, and then you watch a $23.8 million courtroom judgment become part of the biggest crisis in your company's history. How does an ice cream packaging dispute become a bankruptcy story? Rebel Creamery spent years building its Rebel Ice Cream brand. They targeted a highly specific demographic, positioning their products to appeal directly to the low-carb, keto-friendly market. This operation successfully scaled its distribution, pushing physical pints into the frozen food aisles of major national retailers across the United States. In the consumer packaged goods industry, claiming that kind of physical real estate is incredibly difficult. Then, the narrative abruptly shifted. On August 14, 2026, Rebel Creamery LLC filed for Chapter 11 bankruptcy protection. The legal filings were processed in the U.S. Bankruptcy Court for the District of Utah. A brand that appeared highly visible and actively competing in national grocery chains suddenly entered court-supervised restructuring. We often assume that reaching national distribution guarantees a company's safety. Retail visibility can easily create an illusion of financial stability. To understand how an established ice cream brand gets into this level of trouble, we have to look past the grocery store shelves, bypass the marketing, and examine what broke inside their balance sheet. This clean balance sheet visualization shows the stark financial reality reported in Rebel's initial Chapter 11 filings. They listed approximately $13.78 million in total assets. Standing next to that figure is a towering bar representing approximately $23.85 million in total liabilities. As the same diagram isolates the liabilities, we can clearly see one specific item driving the imbalance. Rebel listed a massive $23.785 million claim connected to rival Leeuwen Ice Cream. Rebel marked this massive legal claim as disputed and under appeal. The $23.785 million judgment appears to be a major financial pressure point, but the court filings do not establish that it was the sole cause of the bankruptcy. A liability of that size, however, exerts immense strain on any operation possessing roughly $13.78 million in assets. This extreme anomaly in the ledger forces us to ask a difficult question. How does a corporate dispute over the visual packaging of an ice cream pint evolve into an existential financial threat to a national brand? To understand the origin of that $23.8 million liability, we must look at the physical product. Rebel was fighting a daily war for shelf space against aggressive competition. Manufacturing ice cream efficiently at scale requires complex automated production lines and massive capital overhead. But producing a quality item is only half the equation. When customers are standing at the checkout line or scanning the frozen food section, visual branding dictates their behavior. The outer packaging is what actually captures attention, communicates the brand's value, and secures the sale. This reliance on visual packaging brings us to a specific area of intellectual property law known as trade dress. Trade dress is the visual identity of a product, the exact look, color scheme, and layout that makes consumers recognize where that product comes from before they even read the name on the label. This graphic visually defines the exact elements in dispute. In a lawsuit dating back to 2021, Leeuwen Ice Cream argued that Rebel's packaging infringed on their proprietary trade dress. The court proceedings focused on highly specific visual traits, including a pastel or monochromatic appearance, a minimalist design layout, and distinctive black script-style lettering. A brand's packaging is valuable commercial property. Because visual identity is protected by law, imitating it can pull a consumer goods company into a devastating legal battle. On July 16, 2026, a federal judge ruled in favor of Leeuwen in the packaging dispute. Based on the evidence presented at trial, the court found intentional trade dress infringement. The court's order carried two heavy consequences. First, the judge ordered Rebel to stop using the infringing packaging and required them to completely redesign their look. Second, the court awarded a massive financial penalty, calculating the damages directly from Rebel's profits tied to the infringing products. And then came the number that changed the story. This numerical counter shows the exact penalty awarded by the court: $23.785 million. Tracing the chronological pins on this timeline reveals a rapid sequence of events. The court issues the heavy judgment on July 16th. Rebel continues to dispute the allegations and files a formal notice of appeal on August 12th. 2 days later, on August 14th, Rebel files for Chapter 11 bankruptcy protection. The timing is striking, but the court filings do not explicitly establish the lawsuit as the sole cause of the filing. Chapter 11 allows a business to continue operating while it attempts to restructure. It is a court-supervised process that gives a company space to manage its creditors and navigate crippling legal and financial obligations. We can extract 4 specific lessons from the Rebel Creamery bankruptcy. Lesson 1. Branding is a protected asset. A product's visual packaging has tremendous commercial value. Lesson 2. Competition has strict legal boundaries. Businesses can study their competitors to understand market trends, but directly copying distinctive branding can create catastrophic legal risk. Lesson 3. Legal risk inevitably becomes financial risk. A dispute may begin over fonts and colors in a courtroom, but the consequences eventually drain cash reserves, disrupt inventory lines, force operational restructuring, and heavily complicate a company's relationship with its creditors. Lesson 4. Growth does not eliminate risk. A product can succeed in securing distribution, reach major American retailers, and still face overwhelming pressure if a single massive liability outgrows the company's financial resources. Revenue and visibility do not automatically equal financial safety. Securing national distribution provides income, but it cannot insulate a brand from the destructive force of a heavy legal judgment. The next chapter is unwritten. Moving forward, the industry will watch the outcome of the bankruptcy proceedings and the ongoing appeal regarding the disputed claim. They will also watch how Rebel executes its mandatory packaging changes and whether those changes impact the brand's long-term retail presence. Was this a packaging mistake, or is it a warning about how modern consumer brands manage intellectual property? If a company can lose millions because the look of its product crosses a legal line, where exactly should businesses draw the boundary between inspiration and imitation? Now here's the question I want you to answer. Do you think Rebel Creamery's bankruptcy was mainly a legal problem, a financial problem, or a combination of both? Let me know your opinion in the comments below. If you like breaking down the business decisions, legal battles, and financial mistakes behind the headlines, subscribe to the channel. We analyze the underlying mechanics of corporate crises to find the strategic lessons that every brand needs to understand. Until next time, keep questioning the story behind the numbers.